as it is, I still hear the vibrates half the time, and I find it annoying personally, but no problem with that. Thank you. Welcome all for coming. This is the first of many, hopefully, lectures, speeches, questions and answers with all different topics that you guys have asked for that we'll be having. This is Matt Cubeiro.
Yeah, I can't even roll the R either, so.
Cubeiro.
Yeah. That's better than I can do it. So.
Michel Associates, one of the preeminent law firms in California dealing with Second Amendment rights and various other issues as well. Matt is also one of the preeminent lawyers dealing with Second Amendment issues and other issues as well. He has some prepared information he's going to share with you. He did send me some information late in the day today, which I will forward to you all and to everyone else for you to have. He's going to talk a little bit, then have some Q&A, and everything should be good. Thank you all for coming, and thank you, Matt.
Well, thank you. Thank you for inviting me, Peter, and thank you for having me. I know this is it's nice to see a facility such as this actually be able to open in California. That's especially in places like Los Angeles. That's a rarity, to say the least. So Peter already kind of introduced me. My name is Matt, so I'm one of the attorneys at Michel Associates. Have any of you heard of our office before? Okay, so some of you have. Okay, so we're counsel for the California Rifle and Pistol Association. We've also helped Peter and the range here a little bit, and what I do personally at the office, for those of you that are wondering, is I'm what's called the regulatory compliance guy, which is another fancy way of saying if you have questions on what the laws actually are, how they work, how they apply to you, I'm the guy that you want to talk to. So personally myself, I've been involved in the shooting sports for a number of years, well over a decade. I myself am a certified instructor, both through the NRA, CRPA, post-law enforcement. I teach law enforcement regularly on California gun laws and federal gun laws. And so if you guys have any questions today, I want to make sure they're all answered to the best extent possible. I just have a couple caveats. First and foremost, we are recording this. This is getting live streamed. And, you know, for the sake of everyone here, I'm sure we're all friends, but if you want to talk to me about your unregistered machine guns in your basement, I would encourage you to maintain some level of attorney-client confidentiality and come see me afterwards. So just keep that in mind when you're asking questions. The second thing, and this is really something that I tell everyone that I speak to, is that I'm very good at what I do, and I've been doing this for a long time. And you will have a hard time finding someone that knows more about California and federal gun laws in the country. But I say that not to stroke my own ego. I say that because when I tell you that even I don't understand what some of these laws are or how they work, you get my full meaning. Because unfortunately, we're in a state where legislatures enact laws that often don't make sense or don't have any practical application or how they should be enforced, or just in generally are confusing to everybody, including people like myself. So to the extent, you know, what we're talking about here today, if you guys have questions on things, I will do my best to answer them. But there's also things that I talk about, generally speaking, that I want to talk about more in a client confidentiality setting for various reasons. So I'll tell you if it's something that we should talk afterwards if you guys have questions on or things like that, okay? Does anybody have any initial questions for me or what I do or what we're talking about here today? Okay, so with that being said, how many of you are residents of LA County? Okay, so pretty much everyone here is a resident of LA County. So I bring that up because one of our lawsuits that we currently have that's pending is CRPA v. LASD. We have filed a lawsuit challenging the LA County Sheriff's Department's CCW policies and procedures and practices. Has anybody been following that lawsuit at all? So a couple of you have. So for those of you that are here, if you're interested, for example, in obtaining a CCW, if you know, does everybody know what that is? Okay, so some of you, I won't ask you who has one, that kind of thing. But for the extent that you guys are either in the process or are looking to get one or have never really considered it, one of the benefits of some of the litigation that's happened in the past couple of years, particularly out of the Supreme Court in United States, New York State Rifle and Pistol Association v. Bruin, is that we now have a right to obtain a CCW in whatever state that you reside in. And so as a result of that, LA County was of course forced to create and allow people to apply for CCWs. But the legislature, of course, following that decision, enacted a very restrictive, up to the point as difficult as it could be to get a CCW, as Senate Bill 2, following the Bruin decision, that basically imposed a number of hurdles, restrictions on things like that on obtaining a CCW and how the actual application process works. And so because of that, particularly in LA County being one of the largest counties, not just in California, but in the nation, you can imagine the influx of people that wanted to get a CCW in LA County. And so when it initially started, they were years out in the future just from being able to process your application once you submitted it for a CCW license that's only valid for 2 years. And so, people were looking at, 2+ years wait time for a license that is only valid for those 2 years in the first place. And so that lawsuit is really targeting that, and it's working its way through the courts right now. I bring this up because we're in the process of actually settling with the LA County Sheriff's Department because they've agreed to make some changes in their practices and procedures. And so I don't know if anybody's in the process right now of applying. You might have seen that your application has sort of moved up in the process a little bit. And so they've sort of indicated that what they're trying to do is they're trying to bring everything within compliance of their requirements, probably by October or December of next year. And so hopefully by that time, it's unfortunate that we still have to wait, but the CCW application process will be corrected, I should say, as far as how people get their CCWs here in California. Does anybody have any questions on that?
What are the changes?
Changes specifically in what sense?
To the process.
Okay, so the way the law was enacted following the Bruin case is it created certain requirements that, for example, you can't be what's called a disqualified person. And so basically that's another way of saying that in addition to being eligible to own or possess firearms, you also can't have been convicted of specific crimes. You can't have had a restraining order issued against you, a number of other things that, basically would prohibit you from getting a CCW. And so as part of that, they have to investigate your background, including your social media, character references, things like that. And so LA Sheriff, when they initially started it, they just simply really didn't have the manpower or the financial backing for the department to actually process the number of applicants that they have. And so we're working with a number of consultants and other law enforcement agencies that have been issuing now for decades without issue, Orange County, Solano County, things like that, helping LA Sheriff try and figure out ways to facilitate and speed up their application process, how they go about actually investigating people, the resources that they dedicate, things like that. It's not really necessarily like a policy per se, but just efficiency and streamlining. Does that make sense?
Sure.
Yeah. Okay. Did you have a question?
I do. So the settlement, is it only for the Sheriff's Department in Los Angeles or LAPD, for example? Is this notorious video rate time?
So, yeah, so this settlement has implications in the sense that we've already gotten effective ruling from the court on our challenge to them. And it's so, to some extent, like for example, one of the challenges in the LASD case was how non-California residents couldn't apply for a CCW. And so we were able to get a ruling that said, among other issues, that was unconstitutional. And so they've now had to allow people that reside outside of California to be able to apply for a CCW, because otherwise they wouldn't be allowed to carry, period. And so the case itself, even though it's getting settled, has broader implications throughout California, because LASD being such a large populous county, if they're subject to these requirements, so too should every other county. And so we have other lawsuits though, like LAPD you mentioned, Beverly Hills. Santa Clara is one that's probably going to get filed next week, which we're specifically targeting and challenging the high fees and the psychological testing requirements for CCWs as unconstitutional. Santa Clara, I don't know, for those of you that were noted or were made aware, a number of months ago, they went to the Board of Supervisors and just pulled an arbitrary number of like $1,200 out of their hat kind of thing to say that's what's going to cost you to apply for a CCW in the county. Yeah, and so Laverne, I think, was another one that we did. We actually sued on Laverne, and they actually walked back their fees. And so we'll be challenging other aspects in different counties, as far as like LAPD as one example of, you know, things that they may be doing separate and apart from what's at issue in the LASD case. Does that make sense?
I have a follow-up.
Yeah.
What is the incentive here for them? I mean, you're good at selling, but shouldn't they be penalized somehow? And let's say they, you know, waste somebody's time for 2 years. What are we getting back for that?
They have to pay attorney's fees and potentially damages if they're applicable, which means the taxpayers have to pay for it. So it's an unfortunate, you know, that's our system of government that we have, is that, you know, they are going to be paying some amount as far as, you know, the fact that we had to actually bring a lawsuit to challenge this. And they'll be refunding basically our costs in doing that.
My students went through the Glendale process. One is 3.5 years. One of my employees that I was his instructor just got his permit 3 years and 2 days since he applied to Glendale.
Yeah.
And it's so far it's almost $1,500. They have a background investigation. They have a mental health class that they want you to take.
Yep.
They also have a psychiatrist or a psychologist that speaks with you. It's pretty intense, and you have to carry a separate card in addition to your permit, stating everything that you can and cannot do, ancillary to SB2.
Yep.
As you walk through the city of Glendale.
Yep. And unfortunately, a lot of this is not just limited to the policies and procedures of the individual departments. A lot of it stems from SB2 itself. And so we're looking at potentially filing another lawsuit at some point in the future that's more broader in its implications, targeting specifically the state laws that are allowing these types of things to happen. So the problem is obviously that, you know, most of our lawsuits are on behalf of the California Rifle and Pistol Association. It's a membership, you know, organization that the funds that the membership pays, much like your funds at the range here, go to your memberships. That's what actually is able to allow us to file those lawsuits. And you're talking hundreds of thousands of dollars in expenses over the course of numbers of years. And so we can't do everything that we'd like to do. We have a number of things that we want to challenge, but that's what we're trying to, you know, focus on those issues that not only do we think that we can win, but will make the biggest difference and biggest impact to everybody as possible. So, do you have a question?
I do. I'm a very old lawyer. I've a lot of friends who are lawyers, some who are lawyers, and I've broached the subject, who do I use on an incident, and they go, call me. And I go, but you don't really do this for a living. They go, it doesn't matter. You have someone who's a firearms lawyer versus a criminal lawyer. Please come.
Yeah. So this kind of goes, the first thing that comes to mind actually is this anecdotal story that I have. So my predecessor at the office, his name was Joe Silvoso, and both he and myself handled the criminal cases in the office. And he actually made an interesting point. It's like, if you think about a self-defense shooting, let's say, where a CCW holder is, you know, has to use their firearm in self-defense. It's another way of looking at it is it's the battery where somebody died. And the question is whether or not your use of that force in that situation was justified. And so I can get into some of the more details on that, but one of the big things that people often don't understand is that there are different stages in a criminal case. And when the case is initially filed, typically there's what's called an arraignment. And if it's a felony case, it's felony arraignment. And that means it will go to, at some point, what's called a preliminary hearing. And the preliminary hearing is what, it's like a sort of a sort of small trial, mini trial, to determine whether or not there's enough evidence for the case to proceed to a trial. Whether or not a jury can then be impaneled and selected and then actually go forward with that. And so I bring this up because, like, for example, the issue of whether or not you acted in self-defense is a factual question. And what I mean by that is that it is something that the jury typically would have to decide in order for that to get that question to get resolved. And so when it comes to who to ask as a lawyer or that kind of thing, that's something to keep in mind. That it's not just a firearms issue; it's a criminal issue, and there are different stages when it comes to this. But having somebody that understands the requirements of using lethal force in self-defense is extremely beneficial, because oftentimes, for example, you're able to, as an attorney, negotiate with the prosecutor ahead of time and bring up these factual questions prior to the preliminary hearing and basically convince them and show them that you're going to lose this case at trial, so you shouldn't file it, or we should try and negotiate a resolution kind of thing. And so having that background, that expertise, is what's really helpful. So like, for example, you don't, like, I think you mentioned you're also a medical professional, a doctor. I wouldn't necessarily go to a podiatrist to see something concerning a cardiac issue or something like that. Having somebody that specializes in either criminal cases, criminal trials, and use of force kind of thing is actually very beneficial for reasons like that. And I'm not saying that to promote myself, but just generally speaking, keeping that in mind on who you'd want to have, on speed dial kind of thing if an incident were to happen. Does that answer your question? So, yes.
I have my LAPD interview next week.
Okay.
Have you heard anything from recent interviewees which might be helpful?
So that kind of gets into really the specifics of your background, your history. But just, yes.
Can you repeat the question? Especially
Yes.
back to Ms. Westbrook.
So his question was, he has an interview with LAPD for your CCW, I'm assuming, upcoming here next week. Or is that right? Next week, you said? And so what sort of tips and suggestions would I have for that? Regardless of the agency, the prominent piece of advice that I give CCW applicants is to be open and honest and truthful. Regardless of whether you think, for example, that you had a speeding ticket, 2 weeks ago, whether or not you're not sure if you have to report it or talk about it, do so. Because understand that when it comes to that interview, what they're looking for, among other things, is whether or not you're actually potentially hiding something in your background, or something that you might not necessarily think is relevant, but they nevertheless want to see you be able to come forth with that. Does that make sense?
Yeah.
And more often than not, one of the biggest questions that comes up, for example, is, I smoked pot 20 years ago, or something like that. Should I talk about that? And I was arrested, or I was contacted by law enforcement, or something like that. And the answer is, it doesn't change your eligibility. But what can change that is hiding that and not reporting that. And so that's why it's very important, regardless of what the issue is, just be forthcoming in your application. And if you do have questions on your particular history or things like that, that's where potentially you want to, talk to me ahead of time or something like that in a confidential setting, and we can talk about what that might mean for an individual applying. But just generally speaking, broadly, be open and honest and upfront to the extent possible. And there are things that you can do too. So like, if you've been arrested, or you've had some contact with law enforcement, or you have a speeding ticket, recently, or some other traffic violation, things like that, you can request a copy of your criminal history. You can also request a copy of your driving history, just to have that information ahead of time that, like, for example, you might not have recalled or remembered what happened 10, 15, 20 years ago kind of thing. That's the kind of thing that helps in that situation. So, okay. Any other questions on any of that or anything we've talked about so far?
Matt, what's your opinion on CCW insurance? Is he fully on top about it?
Yeah, so my take on it is that it could never hurt you. And what I mean by that is that if you have the ability to afford it, and what you're paying for is what you want out of it, then go for it. Because at the end of the day, it could only assist in any kind of situation, just as insurance, generally speaking. It's never going to be used against you, or I don't see how it could be used against you potentially in that situation. So having it is always beneficial. And I will say, we are associated, our office at least has been associated with USCCA and CCW Safe. And I've had a number of clients with that insurance policy and haven't had any issues as far as the insurance is concerned. I will say that I'm not necessarily advocating for one over the other. And the reason for that is because, like any sort of insurance that you have, whether it be car insurance, homeowners insurance, CCW insurance, you want to look specifically at the policy and what it is that's being offered as part of that policy, and make sure that you're getting what you want out of that policy. Because not all policies are the same. Some will, for example, provide payment up front for legal services. Others will provide reimbursement, things like that. Or, that's the kind of thing that you need to consider and see what it is that you want out of that policy. But most, generally speaking, will have some sort of like 24/7 emergency response line. And others will be able to, for example, like USCCA, you can designate a particular attorney that you want to have represent you. It might not be the one that you'd be able to get a 24/7 response out of, but when the time comes, kind of thing, they will be able to represent you moving forward. I think. Does that answer your question?
Yeah.
Okay.
What about the cost of defense?
Cost of defense. So as I was saying, that my predecessor, he said like a self-defense shooting is a battery where somebody died. And so typical cost of defense for, let's say, a typical felony case for us is 12 to 15,000 in that neighborhood, up to the preliminary hearing. And so if it gets to a trial, that's where things can get, another retainer would be necessary at that point. Self-defense, you're probably where someone actually has been declared deceased for whatever reason, probably closer in the neighborhood of 40 or 50,000 for a full-blown criminal defense case, if it's necessary. The important thing is, and so one of the things that I sent Peter prior to tonight's presentation here is I've put together a while back a bulletin on California's requirements, generally speaking, when using a firearm in self-defense. And who has a general idea? What do you guys think? What's the sort of general requirement in California for using lethal force in self-defense? What do you have to be able to prove? Imminent danger, okay. Heard something. Anything else? Anybody else? Reasonable. That's the key word. Regardless of what the specifics are of the situation, your actions have to be reasonable. Who can tell me what they think reasonableness means in California law, self-defense law? We have a lot of different answers in here, don't we? Has anybody heard the quote on what a reasonable person is, what the definition of a reasonable man is? Half the world is stupider than they are. Okay? Who's actually judging whether or not your actions are reasonable? And, okay, so your peers. So a jury, right? What is the jury made up of? 12 people that couldn't get out of jury duty.
That's why I said not
Okay,
peers.
yeah, okay. And, those people that couldn't get out of jury duty, what county are you in? Los Angeles, right? So oftentimes people ask me from a self-defense standpoint, they give a hypothetical. Like, what if I did this or what if I did that? That's not the question you should be asking yourself. The question you should always be asking yourself is, can I convince 12 licensed drivers that couldn't get out of jury duty that my actions were reasonable? Okay? And if there's a shadow of a doubt in your mind that you might not be able to convince those 12 people that whatever your hypothetical is on using a firearm in self-defense, that's where I suggest you rethink your action, whatever it is, okay? Because the point that I'm making here is that if you can genuinely say your actions are reasonable based off of what I just described, it shouldn't even get to the point where charges are filed against you. Because the prosecutor should recognize that, yeah, there's no way that this guy should be facing criminal charges for what's clearly a self-defense situation. And for that reason, you shouldn't need to hire me and spend $40,000 to $50,000 to defend you in court. Okay?
What I understand is the civil liability, that's the big pain in the butt that costs all the money.
Even then, in the civil case, yes, you're right. It's a different animal. The standards of proofs are different. But nonetheless, if you're still doing that analysis in your head and what you're doing is a clear cut, you had no other choice, your actions were clearly reasonable. Yes, somebody can file a lawsuit against you still, but they're probably going to lose, and you won't necessarily be liable in that situation. Yes?
You were talking about the CCW insurance
Yeah.
policies in different companies. My research has shown that most of them aren't actually insurance, but are prepaid legal. And I don't know if you wanted to comment on that, because most people think it's insurance, and it's, well, I don't think any of them are actually technically insurance in the state of California.
That's what CE is.
It's a little wonky, but the bottom line is this. The reason why it's wonky is because insurance can never cover a criminal act. And so if your actions are determined to have been unlawful, the insurance by law as a matter of public policy can't cover that act. And so it's like there's kind of this weird, gray area that you're covered, insured, but then that's why some of these policies, for example, have terminology in them that says we can recoup the costs if you're convicted, that kind of thing, for reasons such as that. It doesn't necessarily mean that that actually happens. I'm just saying that is something that, understand just as a legal principle, you can't cover somebody for committing a crime. Does that make sense? So, okay. Does somebody else have a question in the back there? Wasn't sure. Okay. So with that said, I was just talking about self-defense. Does that answer everybody's questions on self-defense? Does anybody else have any questions on that?
I have one more question.
Yeah.
It's a little nuanced and it might be based on each town. But as you know, California handguns, they come with certain features. Like the magazine is going to, which some people find dangerous. If you remove it, is that something that, well, first of all, are you allowed to remove that on your license?
It's a two-part question. Okay.
And let's say it is allowed, can it be used against you?
Okay, so 2 parts to this question. First is, can you modify a handgun that's on the roster? Is effectively your first question. Second question, would that impact your self-defense claim? So in the classes that I give, I like to give this example. If somebody breaks into my home in the middle of the night and I have a choice between my Barrett 50 caliber and my 9mm pistol, what's the appropriate response? Okay, what if the Barrett 50 caliber is my only option? You see the distinction there? What are we going back to? What's the phrase that we talked about that's important in self-defense, right? That's the question, is reasonableness, right? Whether or not your use of force in that situation is reasonable is a completely separate question on your modifications to the pistol. And so a good self-defense lawyer, a good criminal defense lawyer should be able to argue that if you've made some sort of modification to the pistol, number one, it shouldn't be relevant to the question on whether or not your use of force was justified. And number two, if it is somehow relevant, what was the modification for? And so this other hypothetical that I give is like if, let's say I have a 1911, custom 1911, I've modified the trigger pull, I've added a red dot sight, I've done everything I possibly could to make this like a race gun kind of thing, right? For, competition shooting and whatnot. But I still use that gun in self-defense. It's been modified from its original version. It's no longer on the roster. What is my purpose in making those modifications?
Be more accurate to mitigate collateral damage.
And that's the argument that you would make in that situation.
But it wouldn't be, your gun's still on the roster. That's what modification would have no effect on the roster. What's the purpose?
And this goes back to his first question. So understand that California's handgun roster is a point of sale restriction from licensed dealers to individuals. And so what that means is that it's not something that prohibits you, for example, from having a gun that's not on the roster. People in California have firearms that are no longer on the roster, whether because they fell off the roster because they didn't pay the annual fee, or they were, manufactured prior to the existence of the roster. There's a number of reasons, kind of thing. Your possession and use of that is not impacted by that. Does that answer your 2 questions?
Same question for Freedom Week magazine.
Okay. So now we're getting into the magazine issue. First I'll say, does everybody, so his question was, what about Freedom Week? Does everybody know what Freedom Week is?
No.
Okay, so most of you know. So for those of you that don't, there was a period in time following a decision from one of our cases, Duncan v. Becerra at the time, now Duncan v. Bonta, which is currently petitioned to the United States Supreme Court, that as a result of that opinion, there was a period about a week or so where all of California's restrictions on magazines were invalid and unenforceable. St. Benito's, I think. So, so as a result of that, we probably saw millions of standard capacity magazines come into the state of California. That injunction that was originally in effect on the possession restriction is still enforceable and still in effect. And so what that means is that you cannot right now buy or import or otherwise acquire standard capacity magazines in the state of California. But if you already have them, if you're already in possession of them, you can continue to possess them and potentially continue to use them in any lawful manner outside of transferring them. That includes carrying them on a CCW firearm.
What if you acquire those magazines outside of freedom?
Come see me afterwards. Okay.
A couple of years ago, we had a memo saying do not enforce that law.
Yeah, and part of the reason for that is because as a result of that decision, the judge, St. Benitez, ordered California DOJ to send a notice through what's called CLETS, California Law Enforcement Telecommunications System, that basically acted as a notice to all law enforcement agencies that they couldn't enforce this, pending this case. And so as a result of that, we've had a number of cases where people have actually been arrested for possessing a standard capacity magazine, that were able to go, you guys got this, however many months ago kind of thing, you better return it or we're gonna, file a lawsuit against you. And sure enough, they do. So I can't guarantee you that you might not run into that issue where you run into an officer in the field that, sees for whatever reason. Number one, they've contacted you for some reason, so what's happening there? And number two, they see that you have a CCW and you have to show them your CCW gun, and then, oh, lo and behold, they see that you have a plus 10 round capacity magazine. So there's lots of things that have to happen before it gets to that. But assuming it gets to that, you could have that officer that doesn't understand this or just isn't following this and still cause you problems. I can't guarantee that that won't happen, because it does. But in the end at the end of the day, it should be not an issue for you. So does that answer your question?
Yeah.
Okay, so a couple other questions. Yes?
How do you prove that you've acquired it during freedom?
Who's the burden to prove it?
That's why.
Who is the burden to prove that you acquired the magazines? Government always bears the burden to prove that you committed a criminal act. So that kind of goes to what you were asking earlier.
The
So
only caveat though, what happens if the firearm was manufactured after freedom, right? There were no magazines that existed during that time.
what's the statute of limitations? So statute of limitations on that offense is typically 1 year. Okay? So, and they would still have to prove when that actual unlawful acquisition occurred. Okay? And if they can't prove that, there's an issue there. Yes?
I think you've answered the question, but I want to be very clear. I have a CCW, I have a plus 10 magazine that I acquired lawfully. Can I utilize it
Yes.
in my, as a carry in my CCW?
Yes, there's nothing in the law that prohibits you from doing this. I will give one caveat though, and I don't believe LA is doing this, but please correct me if I'm wrong if somebody actually has a CCW, that LA and other sheriffs do have the authority to impose specific conditions and restrictions on somebody's license. And so if those conditions and restrictions are specifically printed on the license itself, and that restriction includes no more than 10 round capacity magazines kind of thing, that was, I see you're checking right now, kind of thing, then, yeah.
No, it doesn't. I was just curious.
That's the only time it would be an issue.
No, it just does the serial number manufacturing model and the
But understand, in that particular situation, let's assume that there was a restriction on the person's license and they were found to be carrying a plus 10 round capacity magazine. The issue would not be the fact that he had a plus 10 round capacity magazine in his gun. The issue would be that he was violating the terms and conditions of his license and therefore jeopardizing the license itself. Does that make sense?
Sure, absolutely.
Yeah. Okay. Did you have a question? Yeah.
Does it matter how many rounds are actually in the magazine at the time of your, just the actual magazine?
It's, so, I guess I'm not quite sure what you're asking.
You're at a 12 round mag.
Yep,
Okay, let's say it extends below the handle so it's a more comfortable grip.
okay,
You only put 10 rounds in it. So when you went to see, so when that police officer said, let me see your firearm, he goes, oh, this is a 12 round mag. And I go, no, there's only 10 in it.
yeah, it doesn't matter how many rounds are actually in it, it's the capacity of the magazine that matters.
You give it
Yeah.
Yeah.
I take it you're a law enforcement officer, okay. So,
And if you do get pulled over, please
okay. Do you have a question?
Yeah, with the standard California spec 10-round magazine, are you allowed to keep one in the chamber plus 10?
Yeah, because it doesn't matter.
So it's all good.
It's the capacity of the magazine itself. Yeah, the firearm is a separate issue. So this actually brings up a good, I'll segue into this. As far as California's restrictions on carrying a firearm, there's three main restrictions. There's carrying concealed, carrying openly, and carrying loaded. And this sort of touches on the loaded aspect of this, and I want everybody to understand this. For those of you that have a CCW, or even if you don't, you're transporting your firearm to the range, what are the requirements if you don't have a CCW? Unloaded and locked container. What does it mean to be unloaded?
Magazine with a different firearm is one mechanical motion.
It's pretty close. The firearm is readily capable of being fired, is the answer, is whether or not it's loaded. So what that means is that there can't be a round in the chamber, that's what we're getting to there, but the magazine also itself cannot be loaded into the firearm if the magazine has rounds in the magazine, okay? That does not mean, however, that you can't have, for example, loaded magazines in the same container, as long as they're not actually loaded into the firearm magazine well itself. Does that make sense? You all understand what I'm saying there? Yes.
So the trunk of the car is fine.
Trunk of the car, so this goes to specifically what constitutes a loaded container, a locked container. And so the trunk of the car is a little tricky. And the reason why it's tricky is it depends on the car. So when you say trunk of the car, is there any way that you can access the trunk from the vehicle's passenger compartment? You can't fold the seats down? You're sure about that? Okay. If that's the case then, and the trunk itself is locked, that's now a locked container. Does that make sense? Okay. Yes.
So the SUVs don't have that.
Exactly. That's kind of what I'm getting at. But so question. Yes.
Does the material of the container count?
Doesn't matter. As long as, so you can have a cloth bag with two little zippers and a little TSA lock on it. That's sufficient.
And there's no restrictions on transporting ammo? The ammo doesn't have to be separate, locked container?
It can be in the same container as long as it's not inserted into the firearm in any way.
Loaded magazine, but handgun is next to it.
Yeah, obviously you want to be certain that there's no way during transport the mag could somehow magically fall into the magazine well, that kind of thing. So, yeah, but you understand what I'm getting at, what it means to be quote unquote loaded.
Or empty mag with one in the chamber.
Exactly,
Yeah.
it's still loaded, yes.
You also clarify that once the trunk is open, your firearms are locked, considered locked.
Correct.
Container, and you transport between vehicle, residence, or vehicle range, which has to be.
Yeah, so I'll get, that's an excellent observation, and there's actually a case on that. I can't remember the name of the case, but it involved California's gun-free school zones. And specifically the question involved whether or not the guy was on his own property, but his own property was like across the street from a school zone kind of thing, okay? So it's like he was out on his porch with his gun. What's the issue there? So this is a good question. So who can tell me what a public place is? Anybody have any thoughts?
Place that's not private?
What's a private place? I see the circular definition. You'd make a great legislature. So it's actually it's more simple than you think. So where are we right now?
We're in a private establishment.
Show of hands who thinks we're in a private establishment. Private property. Public space.
Public space, no, it's a private club.
Because there's specific signage and there's a lock on the door.
Are members of the public allowed to come into the facility?
No, unless you're a member.
Or invited.
How does one actually become a member?
Walk into the facility.
I'm not a member,
You're invited.
okay? What about a movie theater?
Yes.
Private or public? Okay, so you're starting to see what I'm getting at. And so the issue is whether or not the public would be able to enter the property in any way, shape, or form. So your house, from the sidewalk to the front door, public or private?
But it's gated, right?
Okay, so that's the key.
Is it gated?
The question is whether or not the public would have an ability to simply walk onto the property. So an easement, your mailman, Jehovah's Witness, whoever you want to think about, could they potentially come and knock on your front door? That area, for purposes of California's carry restrictions, is going to be considered a public space, even though it is privately owned property. That's the distinction, okay? So when it comes to actually transporting it though, if you are on your private property and still just transporting it, let's say from your car to your house, number one, I've never seen actually anybody get arrested just for that, but also there's generally a general rule of, necessity and public policy that would say that's okay to do because you're in the act of doing it in a lawful manner. You're not what you're doing, for example, like what the guy was doing that was convicted of in this case that I'm talking about, where he was sitting on his front porch across the street with a shotgun in his hand, right across the street from a school kind of thing. Okay? So that's what you just need to be aware of. So, yeah.
So visibility is not an issue here. Let's say that there is a case where nobody can come, but people can still see. I mean, that's also problematic.
Someone calls the cops, there's a man with a gun walking around in his yard. You think that'll generate law enforcement response?
Yeah, I think so, yeah.
Yeah.
But it depends. But it's a private, we don't know that.
You'd probably, though, there'd probably a call for service, I would imagine. Yeah. So, yeah. Question.
So, regarding the castle doctrine.
Okay.
So, does that start in the front door or your front gate?
Good question. So he asked, what about the castle doctrine? Does anybody who can tell me what they think they know what the castle doctrine is? That's the philosophical definition. But what is California's castle doctrine? Like, what does it do? What is the effect?
What's the luxury of?
Yeah, illegal or inviolate entry into your home.
Okay. So I was actually, this had come up recently. You all remember the Trayvon Martin incident where Florida's stand your ground law was heavily discussed in the media, correct? The issue that the media and shall I say politicians often ignore or fail to understand is that there is a distinction between a legal doctrine and a duty to retreat. And so when we're talking about stand your ground castle doctrine, one has to do with whether or not, in order to simply exercise your right of using lethal force in self-defense, you must first exercise a duty to retreat. Meaning that before you utilize your firearm in self-defense, you must try and attempt retreat from the situation. That is a requirement, duty, that some states impose. California does not impose that, okay? It's actually very much in the minority of states. I think there's only like 2 or 3 that actually do. What California's castle doctrine does, though, is a little bit different. And so if you are going back to self-defense, generally speaking, if you are claiming that you acted in self-defense, first off, who typically bears the burden to prove that you committed a crime?
State.
The state does. What are you doing when you are claiming self-defense? You're saying, yes, I killed him, but. So guess what happens? You now bear the burden to prove that your actions were justified. Okay? So the burden now has shifted from the prosecutor to the defendant to prove that their actions were justified, right? What the castle doctrine does is it shifts it back to the prosecutor if the incident, at least under California law, occurred in your own home. The law is going to assume that you acted in self-defense if that act actually occurred while you were in your own home. And now you get to your question specifically. What is your home? And so this is a good question. So the law is not specifically clear on this, and I think for very good reason, because everybody's house is different. And they're not going to give you a bright line rule on what constitutes your home or not, because that's where you start getting these crazy conspiracy theories and stupid ideas of, well, I'll shoot the guy and then drag him into my house kind of thing, and therefore claim self-defense. That's not how it works. What really is the question is, from a self-defense standpoint, it's not clear. And so I would say, just as a starting point, your bedroom, there's no question, right? The further you get away from that, depending on your property, detached building, garage kind of thing, courtyard, at what point does it become problematic? And so this is what brings me to my main point on the Castle Doctrine in California. From a legal standpoint, forget that it exists. The reason being is because it can only help you. What's the key thing in exercising lethal force and self-defense? What's the key phrase? That's the only question you should be concerned about. Because at the end of the day, if the question is going to be whether or not you have the burden or the prosecutor bears the burden, it's not going to matter if your actions are still reasonable. Does that make sense? Because if you can show that regardless of whether or not the Castle Doctrine applied, your actions are still reasonable, you're not criminally liable. So all the Castle Doctrine is going to do is it's going to help you, in the sense that it'll just be that extra sort of layer of protection. But you should never rely on it as your only means of protection. Does that make sense? Yes.
I have a scenario, it's a slight pivot from this. If I am carrying a loaded firearm in a public space concealed without a concealed carry license, and I'm in imminent danger and I have to defend myself, am I entitled to the same self-defense laws as if I were carrying a vehicle?
Did everyone hear his question?
Yeah.
So the answer to that question is twofold. First, whether or not your actions were justified is one legal question. You could also still be charged with unlawfully carrying a firearm. And so you could potentially in that situation be criminally liable for that, but not for using the firearm in self-defense.
Right.
And so in some situations though, like for example, there was a case, it wasn't in California, I can't remember what state it was in, where like the vice principal or something ran to his car to retrieve his firearm because he couldn't have it on campus. And then he was actually on campus with his gun. And so in theory, he's violating the law, the gun-free school zone law, but because he's doing so with the purposes of acting in self-defense, the same standard of reasonableness applies to the self-defense claim for that situation. And so in your case, in your hypothetical, the real question is going to be, are you carrying because there was an immediate threat kind of thing? Then you could potentially say self-defense applies to both potential charges. But if you were just carrying and then happened to then get involved in a self-defense shooting, that might not be the case.
Okay.
Make sense?
Yeah.
Everyone understand that? So get a CCW. Okay? Yes.
In terms of transportation, are there any restrictions? Assuming it's locked in a locked container, does it have to be on me at all times? Can I leave it in my car? Can I walk around with it going places? What are the restrictions?
So as far as transportation is concerned, really the transportation restrictions have to do with those carry restrictions that I mentioned. That California only restricts carrying concealed, carrying loaded, carrying openly. And so a general exception, for example, to carrying concealed and carrying loaded is if you have a CCW. There's a specific exemption to those statutes in that situation.
6015.
I don't even know off the top of my head. So, but, well, technically no. 26150 is the requirements for getting a CCW from the sheriff.
Okay.
So what I'm talking about is the actual restriction, the penal code restriction on carrying a concealed firearm. And as part of that penal code restriction, I can't remember the number off the top of my head, 25400. Under 25400, there's a number of exceptions to that, right? And so that particular code section also states that an exception to carrying, one of the things that you will be found to not be violating the law is if you have the gun unloaded and in a locked container. But beyond that, it doesn't really specify that, for example, you have to be going to and from specific places, just that you're carrying it in that fashion, in an unloaded lock container state. Does that make sense?
Even if you're not carrying it?
But that's the thing. It's not. Don't look at it per se as like you're carrying it. Just as long as it's unloaded and in a locked container, California's carrying concealed, carrying open, and carrying loaded restrictions would not apply to that. Does that make sense? Because not only is it concealed, it's encased, but it's done so in a locked container, so that exempts you from the carrying concealed restriction, and it's also unloaded, so you can't be charged for carrying a loaded firearm. Is your question?
So with your CCW, I think the law says it has to be on your person in language. And does that, if you're in your car, does that mean that you're seated above the parking lot?
Yeah.
That really becomes a problem for us sometimes.
It does. So his question was specific. Sorry, go ahead.
No, that's my
Yeah.
question.
So his question was what it means. What does it mean to be on your person while carrying your firearm? And so he gave the example of, what if you have it in your glove box, utility box, or somewhere else in the vehicle, but it's not like actually on your person in the sense it's not on a holster. Generally speaking, under your immediate possession and control is really the way to look at that. And so if, like, for example, I can reach to it and grab it from wherever I am in the vehicle, that's probably still from a legal standpoint going to be on my person. But this is, again, one of those questions that the sheriff or law enforcement agency can impose specific policy restrictions on how they actually want you to go about doing this. And so depending on what your agency is that you got your CCW from, they could say, as a matter of policy, we don't want you to be carrying in that fashion or something like that. Yeah, so, but just that's where I would first look to that, on that. So, a question in the back first. You had to stand up first. So.
When we're talking about containers and transportation as well, isn't that changing January 1st? And 25.105 is changing the terminology to whether it be the Office of Attorney General have a list of what they consider a lockable device. So
you're talking about the firearm safety device restriction. That's not applicable to these restrictions. So what he's getting at is there was a bill that was enacted actually last year, and I don't remember the number off the top of my head, but it has to do with what meets the definition of a firearm safety device under California law, which can include locked containers, that kind of thing. And so that would be something that, for example, would be a point of sale type restriction, where you go to buy a gun, it's a firearm safety device that you're buying with the gun. You can then take the gun home with you using that as the FSD requirement. Okay, but for purposes of California's carry restrictions, carrying concealed, openly, or loaded, all that's required as far as meeting the statutory requirements of those exemptions is that it be a locked container. It doesn't specify that it has to be a firearm safety device. Yeah, and the reason for that is because the firearm safety device list also includes things just like trigger locks. And so imagine, for example, you're carrying a gun with a trigger lock on it, but openly kind of thing. It's like, well, that's not going to satisfy the exemption either way. So it still has to be in a case of some type. Does it make sense? So, question? Yes?
How does Senate Bill 2 conflict with the carry on driving on the street near school?
Which bill? I'm sorry?
Is it Assembly Bill 2?
Are you talking about Senate Bill 2? For the CCW bill? Yeah.
So going to a restaurant or
Yep.
being on a road near a school.
Yep. Okay. So his question was, how does the sensitive places restriction that you're referencing, generally speaking, how does that apply in this situation? So you have to separate out California's general carry concealed, carrying openly, carrying loaded restrictions, which are in and of themselves their own restriction, versus the sensitive places restrictions that you're talking about that only apply to CCW holders. And so as a CCW holder, what it's telling you is that even though you have a CCW, you still cannot go in certain places. Okay? And so I will say this, that we have a lawsuit on this issue. Some of you may have seen, it's May v. Bonta, that's currently pending. It's going through discovery right now. And so we're anticipating that discovery period will close towards the end of the year. But the state just recently filed like 14 expert reports to go with their discovery. And so it's probably going to get, what that means is probably going to get pushed back a little bit further because of the amount of experts that are going to be involved. saying, you know, what is or what is not technically a sensitive place in California in the means of that restriction. So that case is ongoing. Don't expect any immediate action on it yet, is what I'm getting at. Okay, but
Typically now, what part of Essex, restaurants that serve alcohol, any place that serves, what are the things that we have to?
there's a whole list, and I don't know them all off the top of my head, but I'll make sure to send that to Peter, and he can send that around to you guys as far as what is actually currently enforceable as applied to CCW holders.
I think the
So-
best, right? It's like
Oh, yeah.
buildings, and you could be in a retail center, and a government building, and a retail.
Yeah,
center.
and there's an injunction that some of them are enforceable, some of them aren't, and so it's just it's a whole other conversation. So, yeah.
You mentioned an anecdote, a principal leaving the school in a certain situation to retrieve a firearm and come back. How does it work when it's not self-defense, you already retrieved it, returning to the scene to protect others?
I think he still has a good argument that he's using it to protect other people. And so good, thank you. For purposes of his question, he's talking about the anecdote that I gave of the vice principal going to his car to retrieve his firearm during an active shooter situation, and how that applies because he's already retreated from the situation. And the answer to that question is, at least as far as California law is concerned, now this anecdote that I gave, I think occurred in another state, so it technically doesn't apply. But I'm sure the state has its own similar requirement, let's say. In California, though, you have a right to use deadly force to defend somebody else if that person themselves has a right to use deadly force to defend themselves. Okay? So, caveat to that. There's actual cases on this, though, that you need to make sure, my general advice to people, that whatever the situation is, you're absolutely certain that that person has a right to use deadly force in self-defense. So outside of like your immediate family member, or you see some guy clearly, you know, trying to kill kids or something like that, where it's, you know, no one can question that you're acting in self-defense on behalf of somebody else, you know, maybe just be cautious about doing so. Does that make sense? Any questions on that specifically?
Yes, what's the
Yeah.
distinction?
What do you mean distinction?
The distinction between somebody, where do you draw the line?
How do you know if somebody themselves has a right to use deadly force?
Yes.
That's the question, though.
Yes.
And my answer to that is I don't know. And so it really does depend on the particular situation. And so, I mean, for me personally, I would say if I'm walking down the street with my family kind of thing, and I was able to see the entire situation unfold and understand it from my cell's perspective kind of thing, then yeah, in that situation, I'd probably say you're probably good to go. But one of those documented cases that I was talking about is that somebody else came upon a brawl that turned into a lethal encounter and intervened, and it turned out the guy was an undercover police officer executing a lawful arrest. And so if you don't necessarily know that, or there could be that potential issue, my advice is just to be a good witness at that point. Does it make sense? Okay. Questions? A couple more. Yeah.
Can you touch base on the civil ramification of the self-defense case and what can we protect ourselves and what's the
As far as what type of ramification?
civil?
A civil ramification? So he's asking about what are the civil ramifications of using your firearm in self-defense. The answer to that is anybody can sue anybody for any reason in California. So I can't prevent that from happening in that situation, nor could any lawyer. The question is going to be whether or not your actions are what? And if they're reasonable, then theoretically, I can't say it won't necessarily be the case, but theoretically, you shouldn't be liable.
So then the criminal and civil are tied together.
They're two separate issues, though. And the reason why they're two separate issues is because the standard of proof is different. That's the biggest issue.
That's reasonable. And you decide to
Yes.
do that.
But this is where, like I said, if you are crystal clear, there can be no question that your actions are reasonable. I don't foresee you being also civilly liable somehow in the end. They might still try and sue you. And you know, some of the tactics involved in civil suits include just filing the lawsuit in hopes that you settle, kind of thing. And so that might be, for example, a situation where maybe you want to look at insurance policies on what the insurance would cover.
Also, the burden of defense is different.
And that's what I was going to say. The burden of proof is different. And so when it comes to a civil case, typically it's preponderance of the evidence, meaning more than 50% likely that the person committed some act that results in liability, versus a criminal case, the burden is beyond a reasonable doubt, which is basically free from unreasonable doubt kind of thing, which is a much, much higher standard in order to prove. So does that answer your question?
Because I've been told that they always go, they're not hand in hand, so you can get this case like criminal, but that's you get sued, and I don't understand how this happens.
O.J. Simpson.
Yes.
What happened in the O.J. Simpson case?
He got down.
He lost the civil case. All right. So it is possible, yes. But again, my point is, generally speaking, if you follow the advice that I'm giving you, which is in any circumstance, making sure that your actions are unquestionably reasonable, at the end of the day, you should not be liable. That's the only thing I can really say to that. But does that...
Leave a gun in the car, locked.
I'm sorry?
Can you leave our guns in the car, just locked?
So the question is, can you leave your firearm in a vehicle? The answer to that question is yes. There are specific penal code requirements as applied to CCW holders. So as part of that sensitive places restriction that you were asking about earlier, one of those things that they say and they outline is how you go about, for example, leaving your firearm in your vehicle when you park at a location that you can't bring your gun with you. And so as long as you follow that, you should be fine. But it's generally, again, locked container. And
Car, how does it lock?
well, that's where it goes to the car again. So what kind of car are we talking about?
No access to the BMW.
Okay, so what do you do with the car?
What do I do with the car?
Do you lock the car?
Yeah.
Okay, and where do you place the container? Generally speaking,
The car is the container.
the car will be the container, but one of the requirements for the CCW requirements, for example, is it to be placed out of plain view. And so as long as the container is somehow placed in the vehicle somewhere that's out of plain view, you should be fine. But this also means, like, for example, if you have a truck, you don't leave it in the truck bed.
Right, but what if you
Kind
put
of
it in the pocket of the door so it's not visible? There's someone looking into the car.
How would you determine whether or not you think that that's sufficiently out of plain view?
I know you can't see it in the car.
What's the magical word that I've been using, repeating? It's going to be the same question, basically. Does that make sense? Yeah. Because every car is different, and I can't tell you, that's the law. The law is purposely vague on these issues because they want to be able to make sure that you're at least taking steps that are reasonable. That situation.
I
So.
guess that one comment I leave guns in cars. You realize most criminals get their guns stolen, they pick the gun out in the car.
Right, but in cases of a CCW holder, like I said, so his question was he's making the general point, which is absolutely correct, that most criminals obtain their guns from cars. They steal them from cars. But in terms of a CCW holder, if you have to go into the post office or some other building, you're required to leave your gun in the car.
But
So,
this conversation,
yeah.
we're talking about leaving it locked and leaving it in your car.
Yeah.
Very, even short period of time, it's just gone. It's a bad idea.
Yes, and I agree with that, generally speaking. If you can avoid it, do so. But it's also, unfortunately, the nature of being a gun owner in California.
Take your gun out with you, so pick your poison.
Yep.
Maybe it's a good question, but how do you travel with it on a plane? Like the legal.
Yeah.
Just go through TSA.
So his question was, how do you travel? And this, first off, I'm going to assume domestic. International is a whole other issue, which I won't touch on.
I didn't think of that, but that might.
Yeah. Well, because international, you're now talking about exporting and importing, which you have to get specific approval from the ATF ahead of time before you do that. And even to travel just for like a hunting trip to Africa, there's special forms that you have to fill out, things like that. But for domestic travel, the answer to that question is the same way, generally speaking, that you would travel with your gun in California with certain additional restrictions that come into play with the specific carrier that you're using, as well as the TSA requirements. And so the only thing that I'll point out as far as TSA that I'm generally aware of is the ammunition needs to be in its own like original factory container box. So you can't have it in the magazine kind of thing, but really the way you go about doing this is you go to both your airline's website and the TSA website, and search the website for how you fly with your gun kind of thing. Print out those policies, make sure you understand them, and go to the airport with a copy of those policies should there ever be an issue with TSA asking you questions about what to do.
I'm assuming who has to
Lose
lose
their
their
weapons
luggage.
because of this issue.
Yeah,
It's
it's
gonna
clear.
get confiscated.
Well, you have to declare it when you're flying with it.
You know, it has to be in the jet luggage, doesn't it?
Yes,
Yes.
yes. So
So when you declare it to them, it's in the jet luggage.
you go up to the counter, and there's a procedure that they'll use, and you make sure that you've locked it. You keep the keys. You don't give the keys to the airport, the airline at all, because they don't want their baggage handlers in the back having the access to the container. And so, but just generally speaking, like I said, just print up in advance of your flight both the TSA requirements and your airline carrier's requirements, and just have those handy, because sometimes the staff that you deal with might not know what to do. And just say, here's a copy of the policy, make sure you follow it.
Even if it's CCW, it's the same thing.
Well, CCW, you're still flying with the gun. CCW holder or not, unless you're a certified air marshal, you can't board an airplane with a gun. Has to be checked. Okay? But how you go about checking that is what I'm getting at. Does that answer your question?
Yeah, and I'm assuming there's nuances with different airlines in the States.
Yeah, they're all a little different, but generally speaking, they'll all post their policies, what they require.
As I understand from TSA, though, the issue of the ammo is transporting in there, was the packages, the rounds don't touch each other.
I mean,
Some manufacturers, like we have S&D selling to Deloitte, and they can touch each other, so
I have a lever action gun with the tubular magazine. They touch the primers behind one another.
Right, when it's loaded.
Yeah.
Right, nobody's
But what I'm
flying.
saying is when you're transporting through TSA, they're gonna want it, the rounds not touching each other.
Yeah, and that's,
Whereas manufacturer packaging, you get other containers separate.
yeah, you don't want like the loose bag kind of situation. That's what they don't want. They don't want it rolling around kind of thing. Whatever their reasons are, it's still their policy. You still have to follow it.
So I travel a lot with firearms, and built all the time, and I have a wood-busted box I was putting in. But lately I just been leaving, the rounds in the magazine, and they have not been convenient. So I will just say.
Oh, really?
Yeah, they have not. So
Okay.
lately I have a separate concealed gun case, I take the gun, unload it, put the magazine with the rounds in one of those pockets, and lately they have not been taken, taken it off. Also, either you can have a locked container or have a big Pelican case, and if you have a Pelican case, each hole has to have a lock in it. I also use combination locks, and I make sure that my phone number is on the outside, because the person behind the desk, they don't know, they'll say, this is TSA lock, and you always say yes, but you have a phone number, put your phone number on the outside, because in case they call you, you go back to TSA, they won't let you behind there, but you can give them the combination.
Yeah, but the lock itself for the gun case, if I'm not mistaken, should not actually be a TSA lock.
But sometimes
Yeah.
the people behind the counter will ask you, it's a TSA lock.
Yeah. But that's where I would go, this is your TSA policy, and here's where it says it's not supposed to be that.
And it's a TSA proof hard case.
Yeah, right.
If you have two hasps on it, you can't put one lock on it.
Right.
Two
Yeah.
locks.
Yeah. Question?
Is there currently any legal challenges to that new law where if you get a gun stolen, you go on that 10-year ban list?
You're talking about, I guess, so it's not if you get a gun stolen, you go on the 10-year prohibition list. It's if you negligently store your firearm and you're convicted of California's negligent storage requirements. That's the distinction. So not just that the gun was stolen. It's also shown and you're tried and convicted of a misdemeanor or even potentially an infraction level offense, I think, of California's negligent storage restrictions, which what that means is that if you live with somebody that you know is prohibited, or you live with a minor child, you can't store your guns out in the open. You have to store your guns in a container, generally speaking, that's locked, where they do not have access to it. Or you're able to somehow prove that you took reasonable steps to prevent them from getting access. And so that kind of broadly makes it sort of really up to you on your individual needs of your particular situation. But understand that California law generally requires you don't allow people access to it that shouldn't have access to it. If somebody breaks into your home and steals your guns out of your gun safe, you're not liable for negligent storage in that situation.
And they won't put you on the list.
They will no, because one of the restrictions, or on the limitations, I should say, on that restriction, is that the person has to have permission to be in your home in order for it to be considered a potential violation. So if you live at home alone with no kids and nobody else, you can generally have your guns wherever you want, kind of thing. I will say, though, that there's a law that's taking effect 26 or 27, I can't remember off the top of my head, that was enacted last year, that's now going to mandate lock storage. Yeah, 26. Yeah. So starting next year, regardless of how you store your guns, they still all need to be in a locked container when they're not on your immediate possession and control, kind of thing. So you can still have them out, clean them, work on them at your home, kind of thing, things like that, and even have your kid, next to you. But you can't store them in a way, as it stands right now, where that person can have access to it. Does that make sense? That's the restriction that puts you on that 10-year prohibition list if you get convicted of it. So
So let's say you got a lower receiver, it will have to be functional.
lower receiver is still treated as a firearm.
So you can't, I don't know,
Yeah.
maybe it's just a straight lower receiver.
Yep.
It has to be functional.
Yep. If it is a serialized part that's treated as a gun, it's still a gun. So, and the reason why is because the restrictions that I'm talking about, the California negligent storage restrictions, have different degrees of levels, one of which includes if, for example, the person that took it then injured themselves or injured another person. And so obviously in your situation, your example, I should say, if it's just the lower receiver itself, I mean, there's not much threat of injury there. You'll still be potentially convicted of one of the lesser degrees in that situation. Does that make sense? Okay.
Like brandishing a weapon?
I'll get to brandishing in a second. Hold that thought. Yeah.
Rifles have to be locked storage also.
Yeah, so this law that we're talking about that takes effect next year, it's both long guns and handguns. There's no limitation on
So
that.
2026?
Yes, January 1st, 2026.
Can it be loaded or?
So-
Have a rapid access safe next to the.
Yeah. Do you have the law in front of you, the penal code? Does it say specifically?
It does, 25135 does not say.
Yeah. Okay. So it's just locked in a locked container. That's what I thought it was. I just wanted to make sure. Yeah. Yeah. As long as the gun is secured, it doesn't have access. The access is the key. Is the key. Yeah. 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 I couldn't remember off the top of my head. So, yeah. Okay. Any other questions on the loaded stuff and locked container stuff? So he had a question in the back on brandishing, which is a very good question on what about brandishing your firearm? What do you think is? Yeah. So Penal Code 417. Okay. You have your hand up.
It's a crime unless use is justified with something else.
So at what point is it okay to brandish a firearm?
I mean, the danger is reasonable.
Is brandishing one right?
Let me ask another question. Is brandishing a firearm the use of deadly force?
Maybe.
No, it's just my own.
I'm trying to trick you, so you should all know this by now.
Yes.
The answer to this question is yes, and here's why. If someone was brandishing a firearm at you, would you be under threat of immediate deadly force being used against you?
Yes.
So what is the act of brandishing doing? It's specifically brandishing though. So assault is its own separate crime. But brandishing in and of itself, I would advise, should be treated as deadly force. And so what I'm getting at here is that when you brandish your firearm, you should only be doing so if you're also ready to pull the trigger. And so we saw a lot, especially the last couple of years with the riots, where people were on edge, generally speaking, and they're getting into verbal arguments, and then all of a sudden somebody brandishes a firearm at somebody else, and they claim self-defense. That's not how it works. Because brandishing should be literally the last step before you actually pull the trigger, and I'd almost say it's the same step in that situation. It's never a strictly de-escalation option.
What about saying that you have a firearm?
So that's just saying that you have a firearm. So you're doing what potentially? Well, you're giving a verbal threat, potentially. And if you're giving a verbal threat, that's not necessarily immediate deadly force in that situation. And if you're doing so for purposes of defending yourself, that's on the continuum of force kind of thing, much more appropriate at the initial stages, I would say, than to the point where you actually have to draw your firearm.
Can it be a crime in any way?
Yes. Terroristic threats.
Sorry?
Terroristic threat. Criminal threat. But again, what do we go back to?
Reasonable.
So if you're doing so and you're doing so because you need to for self-defense reasons and you're able to argue a reasonableness standard for a less lethal type situation, so a lower standard in that situation, then you'll probably be okay.
Matt, at what point does that impact your CCW?
How so?
Can they pull it even if you were exonerated of all charges?
So generally speaking, so his question was, how does this impact you if you have a CCW? Like, let's say you either brandish or make a threat kind of thing. So generally speaking, most agencies will temporarily suspend a CCW license pending an investigation. And whether or not you're actually charged or having to found to violate some specific terms and conditions at that point, I can't say how long that investigation would take, but that's most likely the situation. And just understand, if you have a CCW, any contacts with law enforcement, for the most part, are required to be reported to your issuing agency within 10 days, I believe. Some days, sometimes 3, depending on the agency. So you'll have to report that to them either way. And depending on the severity of the situation, they may or may not suspend your license pending an investigation. Whether or not that means it'll actually be revoked at the end of the day really does depend on what happened, kind of thing. Okay? Question?
Well, I wanted to respond. I did brandish on something,
Okay.
and I called.
Do you want to talk about this separate?
No.
Okay. Okay. It's not just making that.
This was a year ago.
It's still within the statute of limitations, so I just want to make sure.
I'm not worried about it.
Okay.
There was a threat, I brandished. It relieved the threat. I called the police.
Okay, so it was reported.
Police did come. I reported it. I called USCCA. I did call. I did report it to the sheriff.
Okay.
It was Santa Monica Police that I called at the time, but I got my permit from LASD.
Okay.
LASD called me. I happened to be away from the phone, and then they called me back and said, "Never mind, we read the report. You're fine."
Okay.
And
Great.
within 2 weeks later, I got my result.
Yeah.
So they didn't suspend me. Basically, nothing happened. Cop ran my gun. He didn't know to look at the back of the license. So then once he did, I told him that it was taken. It took him 40 minutes to show up, by the way. By that time,
What incident happened?
huh?
What incident started?
I walked out of the gym in Santa Monica on 2nd and Santa Monica, East Bronx. I was on my phone. I turned the corner. There was a guy right in front of me. I was maybe 2 steps behind me. He turned and threw his coffee in my face for no reason. Luckily, it was not hot coffee. And then he just kept coming at me, like physically lunging at me, and I kept pushing him away. I'm now in the middle of the street, and I kept pushing him away maybe 3 or 4 times, and finally I'm like, all right. I drew, I just held it this way. He kept lunging at me, which really scared the shit out of me because my impression was, I'm pointing a gun at you, you should stop. And after a couple times of me pushing him away, he finally stopped. A guy across the street yelled, "Don't shoot him." Which I was really appreciative of. And that was basically it. And he was, I don't know if he was homeless or not, but it was a total stranger out of total nowhere. I didn't feel like wrestling on the ground with him, catching hepatitis B, or finding out what he was really trying to do. I didn't know if he had a weapon. I didn't know anything.
Did the officers contact the other individual? Did they arrest him?
Long gone.
So just, okay.
He went down the alley. I mean, it literally took 40. I called 3 times.
Okay.
So it took 45 minutes. I mean, they said when they finally arrived, they said there was some other a killing that they had, something more important.
Okay.
I just didn't want to leave the scene.
No, yeah.
You know,
I commend you. I think that's
annoying, but
I think there's no question in that situation from what you're telling me. That sounds like you acted reasonably. So, good job.
You can swat with your firearm on? You should squat with your firearm, that's a great.
Yeah, well, it was the Ruger 3 LCP, so it's a tiny gun, it's right in my pocket carry.
Matt, did you pretend to the prosecutor on that case?
Matt, you actually been talking for an hour, would you like a glass of water or something?
Okay. Yeah.
It'd be interesting if you actually shot him. It still sounds like you're justified, but it'd be a harder barrier to go, you would have gone through a big trial.
Well, he never actually threw a punch.
Yeah, but it sounds like.
Or never, you know, but he lunged at me,
Lunging
so.
at you, pushed him back in time. It's just, we can play the what if game, but, it's just scary.
So so the gentleman in the back asked, what's if I were the prosecutor? So let me run you through what I'm thinking of. So, and I could already conclude from your situation that I don't really see as a prosecutor that the charges should be followed. But let's say I was that hyper-aggressive Alvin Bragg type prosecutor and wanted to bring charges against you for whatever reason. The thing that I would look at first, so what it means to be reasonable and how a jury actually determines that is another question entirely. And so what that means is that the jury has to look at the known facts and circumstances as they appeared to the person claiming self-defense, in this case you. And then what the jury does is they ask the question of what would a reasonable person in a similar situation with similar knowledge and experience do? And so from a prosecutorial standpoint, what this does is it sort of changes the standard that you apply depending on the person, their training, knowledge, experience, that kind of thing. So for example, the average individual that just bought a gun, just got a CCW kind of thing, responding to that situation, it's probably going to be a pretty broad, what would somebody generally do in this situation, right? Put somebody like me or a law enforcement officer or somebody that does this for a living or kind of thing, an instructor, they're going to be held to that higher standard as far as they're not going to be looked at compared to just a member of the general public, but what necessarily somebody else with that similar knowledge, training, and experience would have. So much like how a doctor, if they're like, charged or someone files a wrongful death claim or some other malpractice claim, they're comparing what that doctor would have done compared to other doctors, right? You all see what I'm getting at, what I'm saying kind of thing? And so when it comes to the question of whether or not a person acted reasonably, what does change or what can change are things like that. Another thing that could change potentially is, let's say, you're clearly a fit guy, goes to the gym kind of thing, and it was a 12-year-old doing that to you. So depending on the other person, the disparity of force between you and the other person could also change that dynamic. And so there's never really a sort of a clear guideline here outside of these are just considerations that come into play. Do you all see how that works?
The question I have is,
yeah.
And I've had people say, sounds like you overreacted. I would have thrown a punch. Do you have to take a punch?
No, because again, the question is what was happening in your mind at that time?
A totally crazy person just attacked me for
I have a baseball bat. I'm running at you with the baseball bat. At what point, how close do I have to get to you for it to be potentially deadly force that you have to respond to? Don't say the Tueler drill.
Close enough that I'm fearful for my well-being.
So you specifically.
Yeah.
So does everyone know what the Tueler drill is? That's kind of what I was referencing in that. How? So my law enforcement officers.
Tueler drill, all it says, some guy, Tueler, did a study where he had people running at officers, actually the way to do it, and how quick an officer will draw his gun and be able to respond to somebody stabbing you. The only conclusion you can get is that within 21 feet, and that's just a magic number, you will get stabbed if somebody's charging you. Now, it doesn't mean you're both not going to be dead, because so you shoot me twice, it takes me 30 seconds to die, we're both dead, but that's all it means. Doesn't mean you can shoot further away, doesn't mean you can shoot closer in, it just means you will get stabbed, scientifically studied. That's all it means.
Yeah, and so this kind of goes to taking off my lawyer hat, putting on my instructor hat. This is where training really comes into play. And so one of the things that I'm assuming your range could potentially do this is, set up a target on one of the moving backstops that you have, and have your friend, as you're practicing your shots, how quickly can you come from a draw and present on target as the target's coming closer to you. Everybody's going to be able to do this potentially, but at different distances.
We program.
It actually programmed.
Yeah. Yeah. And so somebody that is a professional shooter is obviously going to potentially be able to do that much faster than somebody that's not. But this is where that kind of analysis comes in, where it's like, how close is too close, and everybody's different. And so, if your grandmother has a CCW and is carrying it and she's not as fast as she used to be, kind of thing, her range on that situation of how close does somebody have to get before she's in fear of immediate force being used against her can be much larger than somebody else. You all see what I'm getting at with this? Okay, so practice and figure that out for yourself, and that's where that can be really helpful. So
let's say that it's on record that the person who was defending himself practiced and they're good at drawing. That could potentially be used against him, right?
Potentially, yes, it could be used against you, but how is it going to be used against you?
Well, the distance. If this guy's been doing this for a while, he's a competitive shooter.
Right.
Then I have
Big pride.
And so this is the double-edged sword. The more training and experience that you have, the higher standard you're held to. By taking this class with me, you are all held to a higher standard than everybody else. You're welcome. Yeah. Yeah. Okay.
Gotta shift a little bit here.
Yeah.
What's actually considered concealed? Because in my place of business, I open carry. Concealed, I literally pull my shirt out, it covers the holster, so concealed.
Yep.
Wear it in one of those fanny packs or bags, it's concealed. What if I have an old style military holster where it's completely covered and you can't see the firearm? Is that concealed? What constitutes concealed over not concealed?
The law, does everybody hear his question? Understand his question? The law is, again, purposely vague on this issue. And so in reality, though, it shouldn't have a significant impact except as applied to CCW holders. But whether it's concealed or open, California restricts both either way. And so then the real question becomes, if you have a CCW, what do you need to do to make sure that you're carrying concealed and carrying it properly, right? And so there's two things to consider. What does it mean to brandish? We talked about brandishing a little bit already. What is the definition of brandishing under California law? Does anybody know or have an idea? I see him pulling up his phone again. So.
Don't let him look at it.
Purposely showing your firearm.
Displaying a firearm in a rude, angry, or threatening manner. Which speaks to what? Your intent, your state of mind, right? So let's say I'm at the supermarket and I have my gun on my hip and I have a garment on kind of thing, and I reach up to grab something from the top shelf and expose my firearm to 10-year-old Timmy that's standing next to me. Am I brandishing my firearm?
No.
Am I potentially displaying my firearm in an open manner?
Yes.
Yeah. Okay. So two different things between brandishing and openly carrying is what we're talking about. As a CCW holder, can you openly carry a firearm? No, right? And so, again, taking off my lawyer hat and putting on my instructor hat, when and if you get a CCW and you're carrying, one of the first things that you will learn that I learned very quickly is you first decide if you're going to be carrying your gun. And then you decide what clothing to wear around that. You do not decide to put on what clothing you want to wear and then decide that you want to carry your gun. You see what I'm getting at? So make sure that you do your best to have, the proper attire that fully covers the firearm to the extent possible. Now, the other question that comes into play too, though, is what about printing? Does anybody know what I mean when I say printing?
Shows through the clothes.
When it shows through the clothes, right? And so, again, going to the distinction between brandishing and printing, if you have clothing that is clearly showing the outline of your firearm, wear something else. Best example that I can give you is typically CCW clothing you'll find has patterns like plaid or other type of lines that potentially break up.
Or Hawaiian shirts.
Or Hawaiian shirts, you know, that kind of thing. That potentially break up those lines that could potentially print on your clothing. That's the type of clothing that is ideal in that situation, or big heavy garments, jackets, although we're, of course, summer LA, it's a little hard to do that sometimes. But just, you know, again, the bottom line though is that if you're carrying a gun and you're carrying it pursuant to a CCW, consider investing in new wardrobes first. So.
I have a question on going back to brandishing. A friend of mine was walking his dog, and an SUV pulled up. The two guys got out and said, "We're going to take your dog." And
Oh, it's a great question.
And he has a CCW permit.
Yep.
He took out the gun and pointed it at him and said, "How bad do you want this dog?" And he jumped back into the SUV. Was he brandishing?
And if I was a prosecutor, I would prosecute that case. Why do you think I would prosecute that case?
Animals are property, human life.
Say it again.
Animals are property.
Can you use lethal force to defend property?
No.
No. Your pets, as much as you'd like them to be your family members, are still legally considered property in the eyes of the law.
400 miles that way, you can. Arizona.
Yeah. So at least in California. I will say there are some very specific exceptions to that. One of them being, for example, if your pet is being attacked by a mountain lion or some other wildlife, you could potentially use that force to defend your pet in that situation. But unlikely to happen in downtown Los Angeles. I will say it is something that's consideration for me. I have a place in Santa Cruz in the Santa Cruz Mountains. It does happen. So it just depends on where you are.
Signs
So, yeah.
on every corner saying, "Look out, the coyotes are out."
Yeah. But as far as somebody trying to steal your dog.
This is what his case was.
Yeah. So in that case, it's again, the question is not, are you defending your dog? The question is always, are you using deadly force to defend yourself? Or someone else that has the right to use deadly force to defend
Did
themselves.
you report it? No.
Okay.
So can you grab the dog and say you're not stealing my dog, but not do that?
Come see me afterwards.
Okay. But is there a way that you're protecting your dog and you're allowed to protect your own?
Who has the burden? So, okay, so let's say you've been prosecuted for using deadly force or even just brandishing a firearm. If you're claiming self-defense, who has the burden?
You do.
You do. You actually have to prove to a jury of 12 licensed or potentially unlicensed drivers in California whether or not your actions are reasonable. In your hypothetical, do you think you can convince 12 Los Angeles residents of that? Do you want to wager $40,000 to $50,000 on it and your potential freedom? That's the question that you need to ask yourself. See what I'm getting at? So.
Hypothetically speaking, you're involved in, you just leave the court, you're involved in a situation where that's happened, and the police get there. How much information you up to a reasonable court for that situation? How much information did you provide to the police before you, because you're in a panic, you're
My name, I was involved. I'm going to call my attorney now. That's it. And the one thing I will say, just as a practical matter, is if you're a CCW holder or who was a firearm was involved, don't draw your firearm while officers in an attempt to say, "Here's my gun. Please take it from me." I'll ask them to say, you know, "Just FYI, I have a gun on me. It's located here. Could you please remove it for me and take it from me?"
From all the cases in California where they use lethal force in self-defense, what percentage of those cases are classified?
More often than not, you won't necessarily hear about them unless there's like really significant media attention. And so the two that come to mind are ones that I was not involved with. There was the incident that was here actually in LA County, I believe it was Long Beach, of the older gentleman and his wife, where some guys were stealing stuff out of his garage, and he felt threatened, and so he shot the guy, and then he was on the ground and he kept shooting the guy on the ground. Do you all remember that story? I'm sure there was, but it was here in Long Beach, if I'm not mistaken. I don't think he actually got prosecuted, and the reason being is because of his age. And prosecutors have very broad discretion in situations like that, whether or not to even file charges. And I've seen it happen before where, the individual, the defendant in question is, if the guy was like 90, 95 years old, it's like putting him in jail for the last few years of his life isn't really going to serve any public benefit, kind of thing. So they still took his guns and,
Yeah, but if he was younger, you said you can't defend your property.
Right. So, but that's one example. The other example that I actually bring up a lot as far as, and this is a good segue, is warning shots. Is there was an individual that was a medical professional, I believe. He was a doctor or psychologist or something. This was up north in Northern California, like San Mateo or something like that. And it was a road rage incident. And he was driving home and somebody else got super aggressive with him and followed him home to his house. And so he parked in his garage, and this other guy came up onto his driveway and started approaching him in a very threatening manner. And so what he did is he fired a warning shot into the hills, kind of thing. And he still got prosecuted. If I was a prosecutor, I might have considered doing the same. Why?
Unlawful discharge.
You're accountable for your rounds first, and then second, was it truly imminent danger?
That's the key.
Firearm.
If he was truly in threat of immediate force being necessary, he would have shot the person. And so what the prosecutor can show is that you fired a warning shot because there was still that gap, even though it was pretty close, kind of thing, to where your brandishing and use of that firearm was technically unlawful. Now, there was a significant public backlash to that, and the DA eventually backed off the charges there. But I use that as a warning, no pun intended, that warning shots are not something that you should be doing.
Isn't that kind of stupid?
Well, what's again the point that I'm making is that if you have the wherewithal to do something, it's no different than, for example, I'm going to shoot the guy to wound him. If you're able to consciously make that effort to physically wound him before actually engaging in deadly force, your actions are not justified at that point. It's no different in that situation. And so whether or not that's a matter of it's stupid and it's policy that should be changed, theoretically that's been our common law for decades, going back to even Old English common law in situations of self-defense. And so, yeah, there might be policy reasons for or against it, but that's what we have right now. So.
I mean, Matt, I don't know if this goes outside the scope of the class, but if I'm training a client, is professional general liability insurance enough to keep me from getting involved in a prosecution if I'm training them in home defense and they kill someone in the event of a home defense or on the street? Is there anything else you would suggest?
Are you the cause of that situation? So criminally speaking, you should never be. Yeah, so criminally speaking, you're not involved unless you're like somehow a conspiracy or something like that. I don't know. But this then brings up the question of civil liability is really the issue. And so your insurance, this is again a question of what does your insurance cover? And so you want to make sure that whatever insurance you have, whatever you're paying for, is what you're satisfied you want coverage for. And companies will offer you insurance for various things, but you just need to make sure, look very closely at what's excluded from your coverage. And I kid you not, this is true in most cases, and I don't know, Peter, if you can tell me if this is true in your case or not. Ranges, generally speaking, have to have liability insurance for the most part. Many of the range policies that I see exclude explicitly from coverage intentional or negligent uses of firearms for shooting ranges.
Yeah, I paid extra.
So really what those policies cover are like slip and fall for the most part. Have nothing to do with the firearms at all, even though it's a shooting range, and they're required to have that insurance. So look closely at what your policy actually covers and make sure that whatever it is that you have in there is something that you're satisfied with.
Thanks.
Yep.
Can I comment on that? As an instructor, you should carefully document your PowerPoints and things that you did to your students, because there are cases where the student says, well, he told me to do that. And if you don't have it documented, I do not, you can assume from the liability. You just don't want to get involved in that.
Yeah.
For negligence, yeah, in the instruction.
Yep.
Earlier you were talking about like training and the standards of which we're really held to. There are a lot of tactical oriented schools where people get completely kitted up and going out and running their buildings.
Yeah, they're fun.
They're lots of fun. Does that raise that standard too? Can that be
Sure.
liability?
Yeah, it's the same thing. It's the more training and experience you have, the higher standard you're held to. So it's that.
But could the style of training being tactical and aggressive, of room clearing, be used against you in a self-defense?
So it's going to go to, I don't think the training necessarily matters per se. It's when you actually shot the guy, were your actions reasonable? And so having that extra training and experience could be helpful in the sense that you know how to respond properly, but whether or not you actually pulled the trigger and did so justifiably is another question entirely. And so from a legal standpoint, they're two separate things. Does that make sense? So I would encourage everyone, even though you're held to a higher standard per se, as far as when your actions are considered reasonable, nevertheless, that extra training and experience, especially if you follow the general legal advice that I give you, is only going to benefit you for the most part. But yes, there's always that concern. And I hear this question about, well, what type of ammunition should I carry? Or, that kind of thing.
What if they pull up your social media show, you're posting all these photos of tactical gear doing all
Yeah. And so this is where a good defense attorney will argue to have that stuff excluded as not relevant to the question of whether or not you acted justifiably or not. Okay? That being said, you also don't necessarily want to, cross the line in some respects. Like I see people, carrying, like the Rest in Peace ammunition or Zombie Max Tactical or whatever, kind of thing. Probably want to stick more with vanilla things to the extent possible. But just having the training and experience, for the most part, shouldn't be relevant. At least if it's truly an issue where that's not something that has an impact on whether or not you acted justifiably or not. Okay? Go back.
Back to the gentleman over there, you're a very nice man, this is against you. At what point does someone have the right to pull their gun?
So it's the same question.
It is the same question, but why would that person not have to use lesser force?
So the question again is what's reasonable under the circumstances. And again, I can't, this is the hypothetical that I can't give you a bright line rule on. The only way that I can really, I think, right, even in that situation, even in his situation, I can't comprehend as a third party exactly what was happening in his mind at that specific time.
Well, from what I heard, the man was lunging.
Right.
Was there a danger of deadly force?
Right. But so the question is going to be, in that situation, 12 random strangers looking at his claim of self-defense, would there be a legitimate claim there? And
well, his friends said he overreacted.
Charges were never brought, though, so we'll never truly know this question, will we? So, yeah. So, but bottom line, from what he said, just from the summary of the events, I don't think that there's a case there from a prosecutorial standpoint.
I will say this, I think I do feel if I had pulled the trigger, I didn't do it wrong.
That's a different question.
Well, but you said brandishing is the same as pulling the trigger. Basically the
Right,
same
but it's
as-
also going to make sure that those officers arrive a lot quicker than 40 minutes. So it's going to be a much more aggressive response in that situation.
Yeah.
So,
Oh,
yeah.
no, I'm not talking about running officer, I'm talking
Right.
about getting arrested and charged.
Yeah.
But that also is good, it demonstrates your reluctance to hurt another person, right? You're not
I
being
will
overly
say, I don't regret doing it. The things I'm most, for lack of a better word, proud of, I never put my finger on the trigger. I held it back this way because I kept pushing it this way. And I was very cognizant of what I was doing. There was no panic of, bang, 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 bang. So, or accidentally pulling the trigger. So,
And that is, I think, a testament to your training and experience.
I don't have that much training and that much experience.
You have more than most. So, yeah.
Oh, no, I was pointing, and I was yelling, and I was clearly yelling against that. In fact, the witness, who turned out to be someone who worked for the city, came over and talked to me, gave me his card to be a witness, and he goes, you were very clear in your instructions, like, yelling, back off, back up from me.
Yeah.
I just wanted to leave. I mean, I have no idea who this person is. If we're at the gym and we get in an argument, or if you're a friend of mine and we get in an argument, I know you're not trying to kill me, right? We're just gonna tussle, maybe throw a few punches, and then that's the end of it. I have no idea who this person is. He's obviously crazy. I don't know what his intentions are. I don't know if he has a weapon, but I don't think I need to find out. That's my intention. And I don't need to find out if I'm stronger than him or a better fighter than him, because
Or get hepatitis.
it might be, or get hepatitis B. It might be too late for me to pull my gun by the time I find that out. And it takes one punch to knock somebody out. So
It's interesting, you have different experiences, I control Hollywood division, and I will tell you, it has the most homeless people in the world. And from my knowledge, they all carrying weapons, knives, sticks. So, a great outcome, and it was a great outcome. And it's all this what if game, you never know, obviously that was the outcome, but I've seen the other outcome. I've seen when that person's
Sure.
hurt.
Yeah.
So, so there's no single answer. And the only answer is the answer after the fact.
Yeah.
That's the problem with this stuff.
well, the truth is we'll never know because he
That's
walked
right.
away and I don't know if he had a weapon. Still don't know the answer.
We only have about 10 more minutes. And
Let me just say one thing.
So the guy,
So I'd love to get some more questions.
If-
Well, let me go to Barry first. He's been patient. So,
So if someone's approaching you, they're assaulting, I don't know if they're armed or not, I don't know where the law is on that, I've had to recently be threatened for my life. But if I allow them to continue approaching and engage, and I'm carrying, at that point, it seems like it's kind of a free-for-all, which they eminently could be armed.
and that's another argument that you can make in bolstering your claim of self-defense. So his point, his hypothetical that he was making was, if I'm carrying a gun and I'm concerned that, for example, the person is getting closer to me and actually gets in a physical altercation with me, it could turn into a free-for-all, and I could potentially have my life threatened, potentially with my own gun, if I'm understanding your argument correctly. And that's another argument that you would make in making your self-defense claim in that situation. Because what you're doing is, again, you have the burden to prove that you acted in self-defense, and part of that burden includes illustrating your state of mind to the jury and showing them what it was that occurred in your mind, in your perspective. And then the jury asks what somebody else in that perspective would do in that situation. Does that make sense? Yeah, so that's kind of why that's important. So
I
yeah.
have to go back to home defense. I have 3 small children, and there's that going on in our minds. The small children that the home defense probably have a more, I guess, concerning issue for me maybe than others because of that. Now, just because you've been using the word reasonable a lot, and we talked about the bedroom and how far it is, what your house is considered. There has to be some kind of definition of this. If they're beating down the door, let's say there's someone just trying to beat down and break the window or something to get in the house. There's no way to, would it be wrong to shoot them at that point from inside, going out?
So let me ask your question in another way, just so everyone understands this. Can you shoot somebody in the back?
no.
I don't know.
As if they're raping your loved one.
I mean, there's different issues, he's got a point.
I don't want to be like him, where he's now getting attacked, and now there's a weapon, now I can, I have kids, I can.
So that's what I'm getting at, is that you brought up your kids, right? And so there's been one case that I've seen where an individual in California shot a guy and wasn't even arrested in self-defense because it occurred in his own home, and what the guy found was some tweaker drug addict was standing over his daughter fully nude, like potentially about to assault her in some way. And I don't know if he shot him in the back, but nonetheless, the cops were like, yeah, you're not going to prison. You're not going to jail.
Especially
kind
when
of
he
thing.
was breaking in.
But this is my point, though, is that your response to a situation, again, it's like you can equally argue in your situation that you've got kids, just as he was arguing, I don't want to have somebody get in a physical confrontation and potentially take my gun, as a means of illustrating what's going through your mind. And showing that to the jury, potentially, and saying, this is why I had to do what I did. I didn't have a choice. And if that's the kind of argument that you're making, you probably have a pretty good self-defense claim.
What about this slippery slope? If someone just walks up onto the backyard, now I can go through all those thoughts and then start shooting them.
Well, what do you mean, just go through all those thoughts?
Like there's potential for the threat to escalate to where they're now getting close to the house.
But who has the burden to prove that your actions were justified? No, not the prosecutor in a self-defense situation. You do. So you have to prove that. You have that burden. Now, if it occurs within your own home, there's that extra added protection of the Castle Doctrine. They could also potentially come into play. But again, I don't want you to rely on that. But nonetheless, it's like in whatever situation you're coming up with, I go back to the question is defined as, can you convince 12 strangers that your actions were justified? So whatever hypothetical you can envision, that's what you need to ask yourself. Does that help you at all? Okay.
There can't be just an implied threat, there has to be a way in which you believe they can carry it out as well. So someone says from distance, I'm going to kill you, that's not a threat. If they say I'm going to kill you and they've got a baseball bat and they raise it and they're walking towards you, more demonstrable that they have the opportunity and ability to do so.
Imminent, inevitable threat of harm.
I'm not inside and they're either cutting the glass so they can reach in and unlock the door.
That's happening, my kids are not.
Is it imminent threat?
Do you think that if somebody was doing that and you felt threatened, then yeah. But here's the counterpoint, the prosecutor argument. What if it was some drunken kid that was coming home and thought he was going to his house and not yours? How do you know the distinction between that? What if somebody breaks into your home and is just trying to steal your TV? Can you use deadly force in that situation?
No.
Good.
How do I know what else?
But how do you know that?
How do I know what else?
Make sure he's not around to say he was only going for the TV.
There is never going to be a situation where I can say with 100% certainty that your actions are justified or not. You're going to be the ultimate person that has to make that choice. And I can tell you from personal experience, I've had people that have come to classes that I give like this, and they just say at the end of the class, I don't want this responsibility, it's too much for me. And end up deciding that they don't want to have a gun for that reason. And that's perfectly fine.
Clearly it's great. If something were to happen, what would be the best case when dealing with police officers? Just, this is my name, I did it, and I'm calling my attorney?
Not I did it, but...
That's the last thing.
Yeah. So...
Well, to be fair, I did call the attorney. They did say, basically, give your information, don't really say anything. But when the cop was there, I was like, I gotta tell you what happened. I did tell him basically what happened. I tried to keep it minimal. He said I could see.
Here's the cautionary tale that I give, and in your case, I think it was probably okay because you had a period of 40 minutes before they showed up. The concern that I have as a lawyer for clients is that you do not necessarily know how you're going to react in a self-defense situation. And everybody reacts differently. Stages of grief going through, they potentially just shot someone, potentially killed someone, lots of things physiologically and psychologically can happen that could impact how you interact with other people, including law enforcement, and potentially to your detriment. And so that 40-minute period that you had probably was enough for you to your body to, physically relax and collect your thoughts, and then respond in a more reasonable, articulate manner to your benefit. But that's just a guess.
I'm also
But-
guessing a lot of it depends on who the cop is that shows up.
Sure, yeah, but
The guy
understand.
who's like, oh, you're arrested, or just, all right,
With Santa Monica, you're
There's a great training video that I've seen of a law enforcement officer talking about interrogation techniques. And one of the techniques that he gave an example of, and maybe you guys can know this too, is that he brings a suspect into an interview room, and he brings out a little tape recorder and hits the record button and says, just so you know I'm recording this, at any point you want to talk off the record, just let me know, I'll turn it off. The whole room is mine. Okay? So understand from a training and perspective point, from a law enforcement officer's perspective, they're typically trained to get you to talk.
Sure, it's called pretext. It's not lying.
But that's the point that I want to make. And so from just as a broad general perspective from an attorney, the only advice I can really give you is to let somebody else do the talking on your behalf.
They're not your friend.
Okay?
He's your friend, they're not.
Okay.
So, typical, this conversation, the line of whether you shoot or not shoot is very fuzzy. You can hear it. Conversations like this will sharpen up the line. Training, the appropriate type of training, like scenario training, force on force, using a simulator with an instructor.
Absolutely.
Sharpens that line up.
Yep.
And it really is a really sharp line. I can shoot him, I cannot shoot him. But right now, we're playing this what if game, and that line's very fuzzy. And you will go home tonight and start thinking, what would I do? And with proper teaching, instruction, with coaching and instruction, that line sharpens up. But the problem is people go to their gun store, they buy some gun that's totally inappropriate, put it in their drawer, they think they're John Wick. And, no, I'm serious.
Desert Eagle.
And no training, and it's more than just marksmanship training, the safety training. There's a whole other type of training, scenario, situation, where these conversations happen.
Yeah. Don't stop training. Continue to the extent, take as much as you can. So, yes.
I just have a question. We had 2 home break-ins in our block. Just this past month, it was 2 houses away from ours. As a CCW holder, instead of calling the police for help, our neighbors were screaming at the top of her lungs. It was at 10 p.m. She has 2 kids and her husband was home.
So domestic situation or?
They were breaking into the house.
Okay.
They went through the back, so from the front to the back, and they were trying to open the sliding glass door. And she started to scream. She saw them on camera, was screaming, and she started yelling, "I have a gun! Get out of here! I have a gun!" The whole neighborhood, all of us heard her. We heard the screams. They were real loud. From a legal perspective, if you're a USDA holder, like, should you go and help? Should you stay home?
This kind of goes back to what he was just saying.
She doesn't have a gun though. He was just saying that.
But what I'm saying is that this is a very fuzzy line, and for the most part, intentionally so. And so I cannot, as a lawyer, tell you in an immediate action situation where you have to make a split-second decision whether or not your actions are appropriate. You have to be the judge of that based off of what you know and what's your experience at the time. And my cautionary tale with involving yourself in somebody else's situation is that you don't necessarily know exactly what's going on. And so that's the only caveat that I give there, even though it sounds pretty clear-cut. But I'm guessing a lot of the facts that you just articulated, you learned after the fact. Is that correct?
Yes.
And so what did you actually know at the time?
Well, when it happened, we didn't know how many people were involved, how many people were trying to break
Or
in,
who it was?
and who it was, and if she was there with her kids, or she was just her by herself.
Or the TV was on and it was just really loud?
Or that she had
Watching a movie or something like that?
What about if you witnessed it? This week I witnessed it. There were 3 men in front of our house. They jumped over the fence at 4 p.m. They were wearing hoodies. There was an SUV blocked out window. They jumped over. They went to the back of the house. So in my head, I'm thinking they're breaking in.
And again, I can't tell you if there's a right or wrong answer there. you as an individual are going to have to make a moral decision on whether or not you want to engage in an attempted self-defense situation like that. And I don't think there's a right or wrong answer. It's just a question of, could you potentially face legal consequences after the fact? Sure. I can't say that you won't, but at the same time, some people will respond, some people won't, and it isn't necessarily a right or wrong type of question. It's just, do you want to actually respond or not? And you are the only one that can really make that decision.
In that situation, I called the police, Eastern Australian police, the 3 men came back, there's a getaway car and another getaway car in the corner, and they all fled because Eastern Australian police. But the cops didn't show up until they didn't show up actually, then I think about it.
I'll finish with this one thought, generally speaking. We talked a little bit about stand your ground doctrines versus duty to retreat, things like that. And the issue of the doctrine, right? And so in California, we have a castle doctrine, where we presume that you acted in self-defense if it occurs within your own home. In other states, it's a general stand your ground doctrine, which means it will apply regardless of where you're physically located. And so from a policy perspective, I think if we're looking at self-defense as a general policy from a legal standpoint, I think it makes sense to encourage states to pass and adopt general, broad stand your ground doctrines, because what that does, and what we're seeing today in situations that have occurred over the past several weeks, is people are afraid to act morally and justifiably because they're afraid of the legal repercussions that could potentially happen as a result of that. And so I think it's a shame, we've seen some of these situations unfold, like where the individual in New York who subdued a potentially dangerous man was prosecuted after the fact. Versus if it happened in a state that had a stand your ground doctrine, he probably wouldn't have been. And so these are policy decisions that you all could potentially be involved with by talking to your legislature and other people and having this discussion on what do we want out of society? Do we want to have a society that is willing to help others, regardless of the potential legal risks that come with it? Or are we devolving into something else where we're now all afraid to respond because we don't want to lose our rights? And that's a serious question. And it's one that I think, we're seeing more and more issues come up where that's a really serious problem these days. So with that said, I think we're out of time.
We are out of time. Thank you. Thank you, Matt. Everyone's already come up to me. A few people left early have already said thank you. This has been wonderful. Your knowledge is. Matt is available in Michel Associates. I believe you do even small call work, and so if you do have questions, you can actually call him, and you will get paid for that instead of just coming here for free. So you don't get to call him to work for free.
Yeah.
But thank you, Matt. I don't know if you're going to stay long.
Yeah, I'll stick around for a little bit if people have questions.
Thank you so much.
Yep. Thank you.
You can read the bottom line. That's their ancillary permit for the city of Glendale.
Yeah. So that's the.
Yes. By your gun. I will. Special ammunition.
What does that mean?
I knew there was a witness.
So.
Modification.
Yep.
I told him
Okay. Yep. Yeah.
So that's what.
You can generally make any modifications you want to your guns, as long as you're not somehow creating a gun that is in and of itself illegal. Yeah.
The second was jacketed hollow point. That's not a problem, right?
Nope. Yeah, carry what law enforcement carries. A lot of law enforcement carries jacketed hollow points. So.
Thank you.
Yep.
Training.
Yes.
Where does your firm operate?
Our firm itself, this is the type of training that the firm does. So, but sometimes what I'll do is I'll give like the 1-hour self-defense lecture in firearm courses that occur throughout California for CCW holders, things like that, just depending on where I am at the time. So I don't have like a set schedule, or I'm not part of like a specific training group, that kind of thing. I can recommend a couple trainers that I work with though if you're interested. So. Yeah. So. Yeah. Yeah, of course. There you go. Yeah.
What are your thoughts on single shot exemption, both for 2011s and AR pistols?
The problem that I have with the exemptions as it stands is that the gun itself, from a technical standpoint, needs to be built from the ground up as a single shot.
Right, so if I go to 2A zone, have them manufacture an AR pistol, and then it's a virgin frame. And then it's 6 months.
I'm not saying just a virgin frame though.
For $10,000, I put it on consignment, and then I decide I no longer want to sell it, and then I regross it.
So you have to be an 07 like me. You have to have a dangerous weapons. There's all these different things that go into, because I take it into that there's so many things that go into it. You're better off just purchasing a firearm that was a semi-automatic handle that is not law, in the state of California. And also understand that it's a small thing. You have to be very careful.
They have to carry 10 rounds.
Yeah, listen, if you have a 30-round magazine that you're legally possession of into a mag-lock firearm, it is now an assault weapon. You will go to jail.
Question two. Let's say I have my 16-inch rifle, and that's in my trunk. It's completely legal. But I'm also carrying a complete 10-inch in another bag.
So there's a case on this. It's People v. Nguyen. And what this has to do with is what's called constructive possession.
So what if that lower another one?
People v. Nguyen. Nguyen. And so when I say I use the term constructive possession loosely because what it really means is attempted possession of an assault weapon. And so the problem with that individual in that case was that they expressly intended to law enforcement that they were going to reassemble the gun in an unlawful configuration. They actually told the cops that, yeah, I was going to put that together tomorrow, and then that's why they arrested him and charged him. So as long as you don't manifest the intent and express that intent, people possess AR pistols and AR rifles in California without issue. And an AR pistol is by nature itself going to have a barrel length less than 16 inches already. But those could still be interchangeable, and all of a sudden you've got a short-barreled rifle on your hand.
But now if I convert a single shot to a semi, is that treated the same as the modification of removing an LCI?
No, it's not the same. It's not the same because what I'm talking about with the switching of the uppers has to do with creating a gun that in and of itself is prohibited by nature of it being a short-barreled rifle or something like that.
It's an NFA item, federally. And
or that.
California, even if it's a pistol, it's still.
Or even an assault weapon. But if you're just making a modification to an off-roster gun, that when the modification is completed is still a gun that's not generally prohibited, that's fine.
The same implications happen for the 2011.
Yeah.
Those are single shot exemptions. You don't take that price off. As long as the FFL's not clear, you are technically, you're running a fine line.
It's no different than if I were to take my gun to some gunsmith and have them Cerakote the gun, or put an engraving on it, or cutting it for a red dot sight, or doing any sort of modification. As soon as that modification is made, that gun is no longer a roster gun. It's no different in that situation. It's just whatever modifications you make sure at the end of the day it's a lawful modification to possess and have on the gun.
So if he goes from single shot, let's say, he's not an FFL, he goes from single shot to semi-automatic.
That's fine.
I think he maglocks it.
As long as the end result is not prohibited.
Now let's say he throws this into meters. Goes through the droves, and then now be a semi-automatic maglock.
Doesn't matter, because the DROS is not registration. This is why it's tricky. DROS in California is a record of the transaction that took place originally.
Dealer record.
Yeah, dealer. It does not mean that you have to have that exact same DROS record to then sell that gun to somebody else.
Next 4473 here, it says single. When it transfers ownership to a PCC, whatever, on the next 4473.
But what's the prohibition though?
Well, you manufacture firearms. I mean,
what does manufacturing require? Intent to sell for purposes of making a profit.
Yeah, so if you make $1 on it, technically.
Well, you can make money off of the gun. The question is, did you make the change initially with the intent of selling it and making profit off of the sale?
That's an unlicensed dealer.
Right.
And then the second question, let's say like the scenario with the gym. Let's say he was also carrying pepper spray and he actually fired the person. He didn't see a weapon, he thought he had one. Could the prosecutor argue that he should have reached for pepper spray before drawing the charge?
That's not the question. The question is, at the time when he fired, did he have the legal authority to use deadly force? Doesn't matter what happened beforehand. It's when he actually pulled the gun and drew the gun.
Less lethal can't be used against you.
No.
Actually.
It's an extra tool that you might have as a de-escalation technique, but the question of whether or not you actually use the gun lawfully is completely separate from what other option you have. Does that make sense? Yeah, as long as you, again, don't make it into something that's unlawful.
I run faster than you. So I can say that I can run faster. Is that what it is?
You were excellent.
Thank you. Thank you.
And I'm a member of California Rifle
Great.
Association.
Yep.
That's great.
Great.
Should I, instead of, or getting insurance, right? So my CCW in class, and then I'll have the license probably whenever they approve.
Okay.
The class this weekend was approved. So
Great.
me and my partner. So get insurance. Should I just like hire you guys on retainer as a background?
So we don't do broad open retainers.
Okay.
We only do retainers when there's a specific matter that's requires our involvement.
Right.
So which is why if you're looking for that kind of protection, the insurance is great.
Right.
Because they'll provide you that 24/7 immediate response. And then if you need something still further than that, then you can put us on the retainer. Yeah.
So USCCA versus CCW safe, do you have any preference?